Awesome. Hey, Dr. Gary Rademacher here from Downtown's Healthcare, and with me today I have Jim Pagano, who is an attorney up in the Boulder, Louisville area. Welcome to this little presentation here, Jim.
Thanks for having me, Doc.
Yeah. Hey, so basically, I wanted to go into why I got into really learning the personal injury and helping patients. I had a patient 5, 6 years ago that didn't fare well in settlement because I didn't do a good job documenting. And I really realized at that point in time that if I didn't learn how to document cases properly, I was hurting my patients. I was hurting the attorneys that were trying to help these people. And so what I've compiled in the last 5 years is information that I think is critical for any chiropractor or doctor or a legal professional to know, so that you can actually represent these people as best you possibly can. And so we have a webinar coming up on the doctor's documentation necessary to stop lowball offers and win policy limit awards. And that's going to be coming up. It's great information. And Jim, you've actually seen all this information, and could you actually express like how that's helped you with some of the cases that you've had?
I can. Thanks for the opportunity to do it. I'll use two case examples, and to maintain confidentiality, I'll just give them names. The first one is the runner, because it was an ultra marathon runner. She had about 8 weeks of chiropractic treatment with a different facility, then an 18-month treatment gap. Then she came to Downtown Health Clinic, and probably had it was more accelerated care, it was more significant care, more directed at making her better. But it's 18 months after the fact. Mm-hmm. You guys sent the case over. There were enough troubles with it that I thought, well, if we can just make it to where the client doesn't owe any money when she gets out of this, that 18-month treatment gap is typically fatal to a successful recovery. I had some conversations with the adjuster about it and told her that, well, the reason for the 18-month gap is you got to take in mind that this is an ultra marathon runner. She runs 100 miles. Another interesting part of that is she got into the accident on the way to the Leadville 100, then ran it. Okay. Mm-hmm. So that so many things are getting in the way of success on this case from the start. I figure if I can get her out of debt, then I probably don't make a big fee on it, but help her out, help the clinic out, and move a case forward. The key to it was the reason she went back to care was because her State Farm adjuster told her, if you're still in pain, you should go back to the doctor. Mm-hmm. That's why she goes back to the doctor. Now, that's a tough thing to show up to the adjuster, that, hey, the reason she went back is because you guys told her to do that. But we go into the records, and at the intake, there it is. Client's here because she's still having pain, and her insurance adjuster told her to come back and get some care. Now, that explains the gap in treatment, but how can we be successful from that point on? Well, the key is the documentation of why and how you saw an injury, how you were able to take that injury back to the collision, is so clearly and carefully laid out in these records, and not just as a matter of opinion, but with objective tests and objective information where you can point to the adjuster and say, hey, adjuster, this is why the doc thinks this. Mm-hmm. And this is why your own doc would also think this. These are objective facts. They're not subjective opinions of someone who's motivated to try to help this client out. Mm-hmm. That case, whereas I settled it, I'll make up numbers. I thought it would settle for, she probably had $5 in lien to pay off. I thought it would maybe settle for $5. Mm-hmm. Winds up settling for, it was 4 times the amount of the lien. Yeah. And here's what the adjuster tells me. She says, well, the documentation in the records, everything that you told me, I was able to show my team where it was on paper somewhere other than my letter. Mm-hmm. So I would tell you, doc, that what you're doing is not necessarily making my job easier. It does make my job easier. What clear documentation that includes objective tests is reasonable in duration, and if it goes longer, such as this case, 18 months out, it's explained in a way that is supportable and it makes sense. You're actually making the adjuster's job easier. And that's what the State Farm adjuster told me, is that this was a case that she didn't think she'd be able to get off of her desk and settle. But because of the documentation that you gave to me and I was able to give to them, case settled for better than I can expect. And
That's awesome.
I'd like to
Yeah.
say that that's because I did such a great job, but I can't do a good job if, I can't pull magic rabbits out of a hat.
Yeah.
You've got to be able to mine the records. And that's an example of where the records, spending enough time going through it and finding the gems that are in there, and because somebody listened to the runner carefully, wrote everything down, explained everything, that made everyone's job easier and made a case that, 9 times out of 10, nobody takes that case.
Yeah.
His situation with that case was very successful.
Yeah, that's a great example. And I think that we've discussed this many times in my, 25 years of practicing. I've learned that 95% of the time, the reason why a lowball offer is offered is because the doctor didn't document properly. So it handcuffs the attorney, and I would say that it's never the attorney's fault for a lowball offer. I think that falls squarely on the providers that are documenting these cases. And there's an art to doing it. And what I like about this is I created a formula that we give to attorneys that you can just go down this checklist and know, do I have the information or not? Can I take this to trial or not? If you check all the boxes and you have all the documentation there, you're going to know what kind of offer you're going to get. And you're going to know, like, hey, can I take this to court or not? Do I have what I need? And so you said there was one other case, though, that you wanted to go over.
Fits squarely into what you just said, is whether I have what I need, and is the package that I get from downtown, is it complete, and is it something that it will be useful and can produce a good result on a case. The other example I wanted to give you, we'll call him the Beard. Simple rear end car accident. I think he spent about 8 weeks with you, and then was in a maintenance kind of, had tapered off, and it was just, we were giving him the care, and we were probably another 4 or 6 weeks left. It was at that interim point when you sent the package of his records to me with an initial evaluation, not really a discharge evaluation, but kind of a summary for the plan to get him to the end of his care. I felt he probably had another 8 months of time that we should wait, just to make sure that the injuries were stable and we knew what he had. It kind of looked like we knew what he had based on the records that he sent. So that was back when you guys were sending records in paper format. Mm-hmm. So I had this big stack of paper records that I didn't want to keep them, scanned them into my system, packaged them up, sent them to the carrier just so that they could have them. And I figured we'd wait another 6 months and then, circle back to the case. 2 weeks later, adjuster calls me up and says, yeah, need your W-9. I'm going to go ahead and send you the limits on the Beard's case. Went back and more carefully went through those records to try to reverse engineer a bit how this happened. Because all I did was say, I'm the Beard's attorney, got these records from his doctor. I'll call you in a few months. Mm-hmm. And that turned into a limits offer that came back. Client's happy. I'm happy. Adjuster's happy. All of the work was front loaded by the clinic. Again, it was the digitized x-rays were things that the adjuster could kind of get their fingers into. The treatment plan moving forward, very reasonable, made a lot of sense, was kind of, it was a continuation of what was already happening. It didn't look like it was just a bunch of cut and pasted information that was put in the report. And in the end, it was, again, you made the adjuster's job easy. And I don't think that adjusters are evil people, that it's not their money, but they have to work within a certain set of parameters and they have to answer to someone. And when you give them, when you check all of their boxes, they're able to go on to their team and have all of those boxes checked as well. So doing a good job on the front end of that case made everyone's life easier.
Yeah.
And it was a case that, because it lacked the drama and it lacked the really serious injuries that, you know, you can see from as a person's walking by you, you know, it was a soft tissue case.
Yeah.
The document, now that's normally one that you settle for best offer, but it produced the limits, and I didn't even ask for them.
Yeah.
In fact, I based on what I saw, didn't know that it would ever make any sense. It would have actually undermined the claim to ask for all of the limits. But the adjuster tendered them because the adjuster had all his boxes checked, and that's what a good, complete set of records does for.
Yeah.
I say it does it for me, but I was just a conduit of the information.
Yeah.
So
you mentioned a great point, Jim, in that, you know, the adjusters aren't bad people. I mean, they're going to just offer what the records show, because most of them are using a digitized program where they just scan in the reports and a number is spit out. And so it really comes down to what's in the documentation. And, you know, I had a communication a few years ago with an adjuster, and I had gone over everything that we do. And literally this adjuster teared up and was like, you know, can you please, you know, teach other providers how to do this, because it would make my job so much easier, because I want to give money, but I can't based on what I'm getting most of the time. And that was one of the reasons why I decided to like package this up and actually start educating not only providers, but attorneys on this, because we're on the same team here to try to help this individual. And when you look at the National Insurance Institute, some of their studies coming out are showing that 80% of the people involved in car accidents, minor car accidents, have a soft tissue injury and a permanent injury. The question is how bad? And that's where your objective measurements come into play, where you really have to actually objectify the injury, so that it's not my opinion. It's all based on third party on what's going on with that individual. So I really appreciate your time, Jim. Is there anything else in closing that you'd like to say?
You know, thanks for the opportunity, Doc. I hope you guys are safe.
Yeah, same here. I hope you're staying safe right now. Thanks for joining in today, and I look forward to seeing you here really soon.
All right. Thanks, Doc. I'll be there soon.